Hi, I'm John Baxter from Baxter IP. I'm here to talk about technology licensing. Licensing your IP to another party can be an effective way to exploit the IP, particularly if you don't have the resources or experience to develop and market your product or service. Essentially, a license agreement is a contract governing the commercial and legal terms under which the IP owner, termed the licensor, gives permission to another party, termed the licensee, to commercially exploit that IP. A license may extend to all aspects of commercialisation, from using the product or process through to developing it further, manufacturing products, and then marketing, promoting, and selling those products. Importantly, the licensee has the right to use but not own the IP. The owner of the rights will usually receive payments in the form of royalties in return for use of the IP. In this talk, I'm going to go through the structure of a license agreement and demonstrate aspects of this structure with a few practical examples. A license agreement always first specifies the basic rights being granted to the licensee by the licensor. These rights will have a defined scope in the following areas. Firstly, whether the license granted will be exclusive, sole, or non-exclusive. The important question here is whether there will be need for other licensees now or in the future. A sole license is generally accepted to be an exclusive license, except that the licensor also retains commercial rights to exploit the technology in its own right. Secondly, will the right being granted be for manufacturing, usage, or sales, or a combination of these three? How will the licensee be limited in how it makes use of the IP? Remember that in the broadest sense, monopoly provided by a patent is a right to manufacture, use and sell. Thirdly, the geographical territory or territories. In which countries will a licensee be allowed to commercialise the IP? Fourthly, the application field, or a definition of the licensed product and or licensed process is needed. Will a licensee be limited in terms of the types of products or processes that it can use the IP in relation to? Generally, the answer is yes, because patent claims, by their very nature, are written to maximise broadness in the context of existing prior art. Fifthly, you need to define the actual IP being licensed. For example, granted patents, patent applications, registered designs, registered trademarks, common law trademarks, documented know-how and undocumented know-how. Remember that know-how to be licensed should ideally be properly documented and listed in summary bullet form at the very least if this is not possible. And lastly, are sub-licensing rights and or have-made rights going to be granted? The question here is whether the licensee will have the right to license others, and if so, under what terms? Can the licensee subcontract the manufacture of the licensed product? You can see here that it is very important to think of the rights granted in terms of a matrix of these parameters. For example, exclusive manufacturing rights may be granted under a certain set of IP in the US, but non-exclusive sales rights may be granted under this IP for the entire world. IP relating, for example, to a hydraulic system may be licensed for the application of earth-moving equipment greater than 10 tonnes in one territory, and for the application of materials handling or forklift trucks under 5 tonnes in another territory. You can be specific as you need to be here, providing the definitions are rigorous. Such limiting definitions, of course, are particularly important where exclusive rights are to be granted. The message, of course, here is always analyse the rights using a rigid matrix structure, cell by cell, and never grant commercially unnecessary and therefore not valued rights to a licensee. In exchange for the rights granted, the licensor normally expects remuneration from the licensee. The remuneration terms of a license agreement normally at least includes the licensee paying the licensor firstly an upfront license fee and or disclosure fee, and secondly a once-only royalty or a per unit royalty. Sometimes also an annual minimum royalty is specified. If the royalty is a once-only royalty, the payment may be stage-gated. A per unit royalty is commonly expressed as a percentage of the sale price of the product or process being licensed, or as a fixed unit dollar or other currency amount per unit. This is normally indexed in some way to cover the effect of inflation. Again, there are many pitfalls in getting the remuneration terms of a license agreement commercially sound for the licensor, and also unambiguous if they are ever later need to be interpreted by a court of law. Very importantly, you can sometimes win in terms of a foreign exchange gain if you decide to adopt a royalty structure in a foreign currency, but of course you can also lose and lose badly. If you do decide to, or driven to, a fixed royalty in a foreign currency, always at least provide for proper indexation of this royalty. Come back next week where I'm going to talk about the IP provisions of a license agreement and how we define the term of a license agreement.